Hello everyone and welcome to the Regulatory Compliance International webinar series. My name is Devika Kapoor and thank you for taking out the time to engage with this webinar today. So today we'll be having compliance conversations with Dominic Wai, partner at ONC Lawyers, Hong Kong. Dominic is our legal expert for the privacy and data protection module being developed in Hong Kong. So today, we'll be going through the LexisNexis regulatory compliance product. Our legal expert will introduce himself. We'll go through the current legal and regulatory landscape and environment of privacy and data protection in Hong Kong, the module scope, any upcoming trends in the area, key priorities, and some questions from our customers. So now I'll take us through what the LexisNexis regulatory compliance product actually is. LexisNexis is a leading global provider of legal, regulatory, and business information and analytics that help professional customers make more informed decisions, increase productivity, and serve their clients better. Our regulatory compliance product is a legal obligations register and an alerting solution that combines regulatory content with technology to empower you to take control of your compliance obligations. So to develop these modules, we use leading legal and industry experts to provide a practical, plain language interpretation of all of the relevant legislative and regulatory materials so that you don't have to. We are currently rolling out financial crime modules, anti-bribery and corruption, anti-money laundering and counter-terrorism finance, privacy and data protection and cybersecurity across several jurisdictions, including China, Hong Kong, Japan, United States, United Kingdom, and Singapore, with additional modules available in Australia and in New Zealand. All of our modules being developed in China and Japan are available in Chinese and Japanese as well. So now I'd like to hand it over to our legal expert, Dominic Wai. Thank you so much for joining us today. Could you please give us an introduction on your background and your expertise?
Thank you. My practice is in litigation and regulatory compliance. Our practice covers advising clients regularly on the Hong Kong privacy law issues, and we also help clients to deal with the regulators, the Office of the Privacy Commissioner, for cases where there have been data leakage and investigations by the Privacy Commissioner. We've also regularly helped clients who are victims of doxing or social media harassment of their personal data being disclosed on social media to try to help them to stop that kind of harassment. So we are regularly advising clients on the issue of Hong Kong privacy law.
Amazing. Thank you so much for that introduction, Dominic. So could you please take us through the legal and regulatory landscape and environment of privacy and data protection in Hong Kong?
Certainly. The main legislation in Hong Kong is the Personal Data Privacy Ordinance, or PDPO for short, that regulates the collection, use, transfer, processing, and storage of personal data. Now, this ordinance applies to both the private and public sectors. It is technology neutral and principles-based. There are 6 data protection principles, or DPP in short. Now, the first one, DPP1, concerns the purpose and manner of collection, where personal data should be collected for lawful purpose and should be collected on a necessary and adequate basis, but not excessive. And the means of collection should be lawful and fair. DPP2 concerns the accuracy and duration of retention. Data users should take all practicable steps to ensure that personal data is accurate and is not kept longer than is necessary for the purpose that the personal data was collected. DPP3 concerns the use of data. If the data is used for a particular purpose and that purpose is changed for a new purpose of usage, then the express and voluntary consent of the data subject should be obtained for the new use. and the data subject can withdraw the consent previously given by way of a written notice. DPP4 concerns data security, which is very important in this age and time of a lot of cybersecurity incidents and hacking, and data users should take all practicable steps to ensure that the personal data is held against unauthorized or accidental access, processing, erasure, loss, or use. DPP5 concerns openness and transparency. All data users should take measures to ensure that their personal data policies and practices are known to the data subjects. And the last one is concerning access and correction. For data subjects, they have the right to access to know what kind of personal data a data user is holding and have the right to correct. Now, the regulator for personal data in Hong Kong is the Office of the Privacy Commissioner for Personal Data. The Privacy Commissioner have a number of enforcement powers, including the powers to investigate, compel the disclosure of information. They can also enter premises and hold hearings, and they can also inspect personal data system. However, at the moment, the Privacy Commissioner does not have criminal investigation powers, and so some of the provisions in the PDPO, they might need the help of the Hong Kong police to help them to investigate and also prosecute it relating to the criminal offenses under the PDPO. The next slide, please. Now, the PDPO covers personal data of living person in any form in which access to or processing of such data is practicable. So it relates to a living person. And for Hong Kong at the moment, this ordinance does not have extraterritorial effect. So if the data is not collected in Hong Kong, then the PDPO does not have the effect. Apart from the PDPO, the Hong Kong Bill of Rights Ordinance that binds the government, and also the Basic Law, our Hong Kong mini constitution, also recognizes the right to privacy and the right of privacy of communication. The Privacy Commissioner regularly issues codes of practice and guidelines to help the general public or particular industry to know how to comply with the PDPO, in particularly the DPPs. The other main laws that relate to privacy and data protection includes the Crimes Ordinance. Under Section 161, it is an offense if there's an access to computer with dishonest or criminal intent. So if there's a hacker that hacked into a computer that includes smartphones and leaked or stole personal data, that would be an offense under Crimes Ordinance, and the Hong Kong Police can take action. And also under common law for the tort of harassment, public nuisance, and breach of confidence, where sometimes personal data might be disclosed for the purpose of intimidation and harassment. Under common law, this is actionable under tort, and victim can apply to the court for injunction to stop this from happening. And this is have been a very useful tool to stop doxing in Hong Kong.
Great, thank you for taking us through that, Dominic. So now we'll just move into the details of the privacy and data protection module scope for Hong Kong. So we've taken the information which Dominic has just provided an overview of and designed this module to target key aspects of compliance in this area. Our legal landscape covers the following: Electronic Health Record Sharing System Ordinance, Personal Data Privacy Ordinance, Crimes Ordinance, Telecommunications Ordinance, Communications Authority Ordinance, Interception of Communication and Surveillance Ordinance, Hong Kong Bill of Rights Ordinance, Basic Law, and National Law on Safeguarding National Security in the HKSAR. The module also covers the following regulators: so Privacy Commissioner for Personal Data, the Office of Communications Authority, Hong Kong Monetary Authority, and other regulators. Our core obligations in the module can be defined as key categories of tasks, and in this module, we have an overview, data protection principles, access to personal data, correction of personal data, general maintenance, codes of practice and guidelines, qualifying criteria for matching procedures and transfer of personal data, provisions of personal data in direct marketing, investigation, complaints, inspections and exemptions, offences and penalties, transfer of records between authorities, preservation of secrecy, providing prescribed information on demand, and inspection of a company's records. So back to you now, Dominic. Are there any new trends in privacy area of law in Hong Kong?
Now, on the 20th of January this year, the Constitutional and Mainland Affairs Bureau, in collaboration with the Privacy Commissioner of Hong Kong, provided a report, and they want to introduce new legislation in Hong Kong to enhance the powers of the Privacy Commissioner to face the new challenges in terms of privacy law and data protection. They want to introduce a number of powers. For example, at the moment, there's no mandatory notification breach requirement, except for certain regulated industries. So the Privacy Commissioner wants to introduce a mandatory data breach notification regime, where if there's a data breach that have a real risk of significant harm, then the data user should notify the Privacy Commissioner and also the affected individuals. And another requirement is for a data retention policy, so that the data user should formulate clear policy of how long they should keep the data. For example, if there is no longer any use or purpose for keeping the data, then they should have a policy of erasing those data. At the moment, the Privacy Commissioner does not have a direct power to administer fines. They can, if there's a breach of PDPO, they can issue an enforcement notice, but there will only be a fine or a penalty if the party does not follow the requirements under the enforcement notice. So the Privacy Commissioner would like to introduce the power that they can impose direct administrative fines. And they would also like to regulate data processors. At the moment, if a data user outsources its data processing work to another party as the data processor, then the primary obligation is still rests with the data user. But the Privacy Commissioner wants to also regulate this data user, which is in line with provisions, say for example, under the EU GDPR. They would also like to expand the definition of what is personal data, because in this day, there are a lot of issues concerning tracking and data analytics. So they would like to expand the definition of personal data to cover information relating to an identifiable natural person. The other new trends is the use of interim injunction against doxing, because there have been quite a number of doxing cases in Hong Kong. And apart from the government, this is also available to actually anyone who have been affected by unauthorized disclosure of personal data that might have affected themselves or also actually family members. So the courts have been very supportive in terms of issuing injunction to stop people from doxing, and also doxing itself is also a contravention of a provision under the PDPO of unauthorized disclosure of personal data obtained without the consent from the data user and causing psychological harm or other harm of the data subject. So this is also something that, by way of the use of injunction to stop the proliferation of doxing and also the contravention of PDPO. So these are the two new trends in Hong Kong.
Amazing. And what are the key priorities for regulators in this area?
As I mentioned, there have been continued doxing cases in Hong Kong. So for the Privacy Commissioner, they have received a lot of cases. And due to their current restriction of power, they have to work closely with the Hong Kong police to try to investigate in this matter, or also try to ask the government to also take civil injunction remedies to stop the cases of doxing. So this will still continue and be a key priority of the Privacy Commissioner. And in July this year, we have also introduced a national security law where there is a provision that would allow the law enforcement to require some service providers of, say, for example, social media to disclose personal data to stop the publishing of messages on those social media, and also may ask the service provider for assistance to decrypt messages that are encrypted. So in this area, under the new law, a magistrate may issue a warrant authorizing a police officer to require the service provider to provide the identification record or decryption assistance. And identification record includes information about the identity of the person who has published the message on the social media platform. So for this kind of matters, then under the new law, data center or social media providers might be asked to provide assistance for disclosing of personal data. Now, sometimes there might be an issue of confidentiality as to the social media platform and the data center provider for their clients in terms of keeping matters confidential. So under the new law, actually, there are some immunity from civil liability, but it may not apply to all scenarios. So that might be something that the general public, in terms of particularly any data center owners or social media providers, would need to be aware of and seek legal advice.
Fantastic. So now just to wrap up, we do have some questions from our customers. Firstly, as an overview, what is the penalties for breaching privacy laws in Hong Kong?
Now, as I mentioned, the Privacy Commissioner may issue enforcement notice for violation of the PDPO. And if the enforcement notice is not followed, then that is an offense that might result in a maximum fine of $50,000 and imprisonment for 2 years, with a daily penalty of $1,000. Now, if there are subsequent convictions, that might result in a maximum fine of $100,000 and imprisonment for 2 years, with a daily penalty of $2,000. Now, if the breach is in relation to unauthorized use of personal data for direct marketing, then it is an offense and liable to a conviction of $500,000 and imprisonment for 3 years. And also, I mentioned earlier about the unauthorized use of personal data without the data user's consent with the intention to obtain gain or cause loss, or including psychological damage to other person. So for breach of this under PDPO, the maximum penalty for the offense is a fine of $1 million and imprisonment for 5 years.
Wow, okay. So as our last question, what are some of the key compliance issues for organizations?
So I think there are two main issues. One is the notification requirements. I mentioned that while there are no mandatory notification requirements for, say, incident breach of loss of data for the time being. However, under certain regulated industry, the regulators might have requirements under a specific code of conduct that might include actually a notification requirement for the regulated companies to notify their customers if there's such a breach. So for companies that are in certain regulated industry, they must be mindful of this and should not just think that there's no general mandatory notification requirements and therefore they do not need to make such a report. The other key issues of compliance is for the use of personal data for direct marketing. Sometimes companies might forgot to take or seek express consent for use of personal data for direct marketing. And if that's the case, that is already in itself an offense. And there have been prosecution cases in Hong Kong for that. So it's very important to be mindful that not only would the company need to notify the customers that if their personal data is used for this purpose, but actually there are certain specific requirements of seeking specific written and prior consent before they can use the personal data for direct marketing. So it's very important for companies, especially if they might use the customer's personal data for direct marketing, to have this in mind.
Dominic, thank you so much for your time today. Really appreciate it and all of your valuable insights.
Thank you.